Hi guys! Welcome to another episode of Attorney Joe Vlogger, Law for the Everyday Layman. Today we continue with our discussion on the Revised Corporation Code, and we likewise continue with part 2 on my discussion on foreign corporations. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Now, a like on this video or any of my other videos would also be greatly appreciated. So we continue today with our discussion on foreign corporations. Last episode, we discussed the nature of foreign corporations, the license requirement for foreign corporations, as well as the associated rules. Now, as mentioned, one requirement to successfully obtain a license to transact business in the Philippines under the law is that a foreign corporation must have a resident agent. So we'll start with that for today. Under Section 144, a resident agent may either be an individual residing in the Philippines or a domestic corporation, which is lawfully transacting business in the Philippines. Okay? So in case of an individual as a resident agent, he must be of good moral character and of sound financial standing. If the agent is a domestic corporation, it must also be of sound financial standing, but it must further show proof that it is in good standing as certified by the SEC. Now, the purpose and function of the resident agent is to be the entity upon whom summons and other legal processes against the foreign corporation may be served. Okay? Siya yung tatanggap ng mga summons and other legal processes. In case of summons, this is the way that the Philippine courts can acquire jurisdiction over the foreign corporation. The service of any such papers on the resident agent has the same force and effect as if it was made upon the duly authorized officers of the foreign corporation at its home office. As I mentioned in the previous episode, one of the requirements for the grant of the license to transact business is that the foreign corporation must attach to the articles of incorporation which it submits with the SEC the following documents. First, a written power of attorney designating its resident agent. Second, a written consent that service upon such resident agent shall be admitted and held as valid if served upon the duly authorized officers of the foreign corporation. And third, an agreement or stipulation that in consideration of being granted a license, that if the corporation ceases to transact business in the Philippines or shall not have any resident agent in the Philippines, then service of summons or other legal process may be made upon the SEC in any action arising out of any business or transaction which occurred in the Philippines, and that service on the SEC shall have the same force and effect as if made upon the duly authorized officers of the corporation at its home office. So it is clear that for a foreign corporation to do business in the Philippines, it must obtain the required license. And this is contained in Section 150, which says that no foreign corporation which is transacting business in the Philippines without a license or its successors or assigns shall be permitted to maintain or intervene in any action, suit, or proceeding in any court or administrative agency in the Philippines. But such corporation may be sued or proceeded against before the Philippine courts or administrative tribunals on any valid cause of action recognized under Philippine laws. As can be understood from Section 150, and as I mentioned earlier in the previous video, the main purpose of the license requirement is to allow Philippine courts to acquire jurisdiction over the foreign corporation which is doing business in the Philippines in case such foreign corporation wishes to sue or to file a case, no? Or in case it is sued in the Philippines. According to the case of Marshall Wells Company versus Elser and Co., the object is not to prevent the foreign corporation from performing single acts, but to prevent it from acquiring a domicile for the purpose of business without taking steps necessary to render it amenable to suit in the local courts. Again, the purpose is to subject the foreign corporation doing business in the Philippines to the jurisdiction of Philippine courts. In other words, the license requirement is meant to compel a foreign corporation which desires to do business in the Philippines to submit itself to the jurisdiction of Philippine courts and to enable the government to exercise jurisdiction over them for regulation. Take note that it is not the absence of the required license, but the doing of business in the Philippines without such license, which denies a foreign corporation access to the Philippine courts. Again, it's not the absence of the license, but it is the doing of business without a license, which denies a foreign corporation access to the Philippine courts. And even if the foreign corporation does not have a license, it can still be sued. Okay, pwede siyang kasuhan in Philippine courts on a valid cause of action recognized under Philippine laws. In other words, the procurement of a license is not a condition precedent to the filing of any case in Philippine courts by a foreign corporation. However, no foreign corporation shall be permitted to transact business in the Philippines unless it obtains a license, and until it obtains such license, it will not be permitted to file any case in local courts. Therefore, take note of these very important principles. A foreign corporation which is doing business in the Philippines without a license cannot sue before Philippine courts, but it can be sued. Now, second, a foreign corporation that does not have a license and is not doing business can sue before the Philippine courts on an isolated transaction, among others, which I will be discussing later. Okay? Isolated transaction is the thing to remember in case it does not have a license and it wants to sue. Okay? So now, we have to discuss these two very important concepts, doing business and isolated transactions. So for doing business, generally, there is no hard and fast rule as to doing, engaging, or transacting business because the revised corporation code does not define it. And as such, each instance must be judged according to the circumstances of the case. Nevertheless, the Omnibus Investments Code and the Foreign Investments Act define the phrase doing business to include the following. First, soliciting orders, service contracts, opening offices, whether called liaison offices or branches. Second, appointing representatives or distributors domiciled in the Philippines or who in any calendar year stay in the country for a period or periods totaling 180 days or more. Third, participating in the management, supervision, or control of any domestic business, firm, entity, or corporation in the Philippines. And fourth, any other act or acts that imply a continuity of commercial dealings or arrangements and contemplate to that extent the performance of acts or works or the exercise of some of the functions normally incident to and in progressive prosecution of commercial gain or of the purpose and object of the business organization. The fourth is the most important, okay? So you have to take note of that. As long as it can be shown that a foreign corporation entered into a series of agreements like successive sales of its regular products, then it will be deemed to be doing business in the Philippines. It is the performance by a foreign corporation of the acts for which it was created, regardless of the volume of business, that determines whether or not it needs a license to operate in the Philippines. To constitute doing business, the activity undertaken in the Philippines should involve profit making. Now, there are two generally accepted tests on whether the foreign corporation is doing business. The first is the substance test, okay? And that is whether the foreign corporation is continuing the body or substance of its business or enterprise for which it was organized, or whether it has substantially retired from it and turned it over to another, okay? The second test is known as the continuity test, in which a foreign corporation's acts imply a continuity of commercial dealings and arrangements and contemplates to that extent the performance of acts or works or the exercise of some of the functions normally incident to and in the progressive prosecution of the purpose and object of its organization. Now, under the IRR, or Implementing Rules and Regulations of the Foreign Investments Act, it gives us a list, no? The following acts shall not be deemed doing business in the Philippines. First, mere investment as a shareholder by a foreign entity in domestic corporations duly registered to do business and or the exercise of rights of such investor. Second, having a nominee director or officer to represent its interests in such corporation. Third, appointing a representative or distributor domiciled in the Philippines which transacts business in the representative's or distributor's own name and account. Fourth, the publication of general advertisements through any print or broadcast media. Fifth, maintaining a stock of goods in the Philippines solely for the purpose of having the same processed by another entity in the Philippines. Sixth, consignment by a foreign entity of equipment with a local company to be used in the processing of products for export. Seventh, collecting information in the Philippines. And eighth, performing services auxiliary to an existing isolated contract of sale which are not on a continuing basis, such as installing in the Philippines machinery it has manufactured or exported to the Philippines, servicing the same, training domestic workers to operate it, and similar incidental services. So those are acts which shall not be considered as doing business in the Philippines. And since it's not doing business, the foreign corporation in those cases does not have to obtain the license. To be doing or transacting business in the Philippines, the foreign corporation must actually transact business in the Philippines. Okay? Meaning, it must perform specific business transactions within Philippine territory on a continuing basis in its own name and for its own account. For the simple reason that the Philippines has no jurisdiction over commercial acts performed in foreign territory. Okay, dito lang tayo. Okay? Wala tayong pake dun sa labas. And in order to do business here, the foreign corporation must obtain a license. Take note that a foreign corporation will not be regarded as doing business in the Philippines simply because it enters into contracts with Philippine residents if such contracts are consummated outside the Philippines. Okay? So again, a foreign corporation doing business in the Philippines with a license is allowed to file a case here in the Philippines. But if it is doing business without a license, it will not be permitted to sue in the Philippines. Now, whether it is doing business with or without a license, it may still be sued or a case may be filed against it before the Philippine courts. Now, let's talk about isolated transactions. A foreign corporation which is not doing business in the Philippines obviously does not need to get a license because it's not doing business here. Okay? And if it is not doing business in the Philippines, such unlicensed foreign corporation can sue or file a case before Philippine courts to protect its interests. No? Some of the cases would be to protect its trademark or trade name, okay, from abuse or infringement in the Philippines, no? Or for non-business transactions, such as where there has been misdelivery of goods to the Philippines, which was not the intended port of destination. Another would be when in the contract, there is a stipulation that the Philippines is the venue of the case. Another would be when the party is bound by estoppel. And one more, which we will be talking about right now, is what is known as the isolated transaction. So a foreign corporation which is not engaged in business in the Philippines may file an action in Philippine courts for an isolated transaction. Okay? And what is an isolated transaction? It's a transaction or series of transactions set apart from the common business of the foreign enterprise, in the sense that there is no intention to engage in a progressive pursuit of the purpose and object of the corporation. Take note, however, that the term isolated transaction does not literally mean one or a mere single act. Okay? You have to distinguish. What is determinative of doing business is not really the number or quantity of transactions, but more importantly, the intention of an entity to continue the body of its business in the country. Okay? So don't determine it by the number, because a single act or transaction may be considered as doing business when a corporation performs acts for which it was created, or in case it exercises some of the functions for which it was organized. Okay? The act, for example, of participating in a bidding process may constitute doing business, because it may show that the foreign corporation's intention is to engage in business in the Philippines, no? Because the bidding might have been for performance of further acts within the purpose or purposes of the corporation. Okay? So you really have to check whether it's the intention of the foreign corporation to keep doing its business. Okay? In other words, while an isolated transaction will not result in the foreign corporation being deemed as doing business in the Philippines, where, however, it is shown that the single act is not merely incidental or casual, but of such character as to distinctly indicate a purpose to make the Philippines a base of operations for the conduct of the ordinary business of the corporation, then the transaction constitutes doing business for the purpose of the law, and therefore the foreign corporation must obtain a license. So let's say here in the Philippines, no, I buy a bag online from Corporation S, which is located in Hong Kong. Should Corporation S obtain a license to do business here in the Philippines? Of course not. Okay? Corporation S does not need to obtain a license because it's not a Philippine corporation. It has no offices, no employees here. Okay? It has no need to obtain a license. Now, even if that one transaction involves many bags, no, not just one, let's say 15 bags, okay, for the purpose of me reselling those bags, will Corporation S be deemed to be doing business here? No. Okay? Why? Because I was the one who bought the bags, and ownership is transferred to me for the purpose of resale. It is not Corporation S who is selling them. Okay? Therefore, it's not doing business here and does not need a license. So let's say I did not pay for those bags. Can Corporation S sue me here in before the Philippine courts? Yes. Why? Because that is an isolated transaction. Corporation S did not intend to do business in that one transaction where it will be many bags. so it will not need to obtain a license in order to sue me. Now, the answer may be different if Corporation S sets up a physical site here, or even if it does not, if it hires someone as its agent to sell the bags repeatedly without transferring ownership to the agent reseller, then that may constitute doing business. Why? Because there is evidence of intent of Corporation S to continue the body of its business here in the Philippines. As such, Corporation S should obtain a license to allow it to sue before Philippine courts. Of course, the correct answer in any case will depend on the facts and circumstances of the case. Just remember the rules and the tests. So, if a foreign corporation does business in the Philippines without a license, what is the status of the contracts that it enters into? Okay? On one hand, they will be unenforceable and because they can only be enforced if the corporation has a license. On the other hand, it would seem that such contracts should also be considered void because under the Civil Code, acts which are executed against the provisions of mandatory or prohibitory laws shall be void, except where the law itself authorizes their validity. However, such contracts shall prejudice only the guilty party and not innocent parties who may have dealt with the foreign corporation in good faith. Why? Because it will be unjust if the non-complying foreign corporation will be allowed to escape liability by merely setting up its non-compliance as a defense. In this regard, note also that a foreign corporation doing business in the Philippines without a license can still sue a Philippine citizen or entity on a contract on which the Filipino citizen or entity has benefited. Okay? They can sue that Philippine citizen or entity in Philippine courts. Why? Because the Philippine citizen or entity is stopped or prevented from challenging the personality of a corporation after it had acknowledged the contract, after having acknowledged the personality of the corporation by entering into a contract with it. Okay? This rule is intended to prevent a Filipino citizen or entity which contracts with a foreign corporation from later on taking advantage of the foreign corporation's failure to comply with the law, especially where the Filipino citizen or entity has benefited from the contract. In other words, it's to prevent unjust enrichment on the part of the Filipino citizen or entity. So, to sum up the rules, if a foreign corporation does business in the Philippines with the required license, it can sue before the Philippine courts on any transaction, and it can be sued. Second, if a foreign corporation does business in the Philippines without a license, it cannot sue before Philippine courts, but it can be sued. Third, if a foreign corporation is not doing business in the Philippines, it does not need a license to sue in the Philippine courts on an isolated transaction to protect its trademark or trade name or on a cause of action entirely independent of any business transaction. And finally, if a foreign corporation does business in the Philippines without a license, a Filipino citizen or entity which has contracted with the foreign corporation may be stopped from challenging the foreign corporation's corporate personality in a suit brought before the Philippine courts. Okay? So that's it for my discussion on foreign corporations. I hope you may have picked up a thing or two, and I hope to see you next time, guys. See you soon. Bye.